Hello, I'm Paula Doolan, and on behalf of the MGA, I'd like to welcome you to our webinar this afternoon being hosted by Kennedy's. But just before I introduce our speakers, I'd just like to run through a few housekeeping points if I may. You should all be muted and cameras turned off. The webinar is accredited for CPD points if relevant to your ongoing professional development programme. And the video of the webinar will be available after the event, hosted by YouTube on our website. And following the event, we'll email you for valuable feedback, please. If you'd like to ask a question, please do. And for our regular webinar goers, they know you go to the chat button at the bottom of your screen. And this will be answered at the end of the session by way of a Q&A. So today's webinar, Emerging Risks in Injury Claims, is brought to you by partner Joe McManus and associates Kim Boland and Rob Corrigan of Kennedy's. They'll highlight what emerging risks MGAs and insurers should be alive to. So a very interesting presentation awaits you all. So over to you, Joe. Thank you.
Good afternoon, and thank you for those words, Paula. Just to very quickly recap what we're going to be looking at and talking about over the next hour. Essentially, I'm going to be looking at the issue of homeworking and what that involves and legal obligations around that. Kim Boland, who works with me, she'll be looking at the very current issue of accommodation following the recent decision in the Court of Appeal in Swift and Carpenter. And Rob Corrigan is going to finish off by looking at psychiatric inflationary factors in injury claims. So quite a diverse range of topics, but hopefully you'll find some or all of them interesting. So moving on to homeworking. This year has seen the largest and biggest change in working patterns during our life, really, with the COVID-19 pandemic. This has really sparked a mass retreat of white-collar workers to their homes. A recent survey found that almost half of all working adults were working from their homes in July, and that was after the first lockdown had ended. This raises the interesting question of whether workers can now be classified as home workers. The term home worker is not legally defined. There is no definition of home worker in the Employment Rights Act 1996. A home worker will generally be regarded as someone who either works exclusively at home or splits their time between home and the office place. And frankly, I think most of us can now be regarded as home workers. So what about the impact of working at home? Well, essentially, it's brought home to many businesses that essentially they're going to be able to work more. The staff are going to be able to work at home more in the long term in the future. In October 2020, the Institute of Directors surveyed 1,000 firms. 74% said that they planned to maintain home working in the future. Over half those businesses also were looking at whether they were going to reduce the amount of office space that they were hanging on to or they're holding on to at the moment. And undoubtedly one of the changes that we're going to see with home working is more and more businesses really encouraging their staff to work at home. However, there are some issues about working at home. Bupa reported that its health and well-being line had received 300% more calls since the coronavirus had started. The Institute of Employment had found that there were higher levels of drinking and anxiety generally amongst workforces. In their survey, 20% admitted to drinking more alcohol and 60% to doing less exercise, with 40% working more irregular working patterns. And I think that's something, some or all of those we can probably relate to. As I deliver this presentation today, we're into the 5th day of England's second national lockdown. And while it feels a little bit different to the first one, Undoubtedly, the fact that we're moving into winter means that there's going to be an impact on mental health. A recent survey by City AM found that 4 out of 10 British office workers feared that their mental health and well-being will suffer if they're forced to work at home over the long term. And I'm going to look in some detail about the risks to mental health in my talk. Okay, so what about the legal obligations in relation to home working? Well, essentially, as the slide states, there's an obligation under Section 2 of the Health and Safety at Work Act to ensure that employers must provide safe systems of work and equipment, and that they must also provide relevant information, supervision and training to users to help them identify the risks and safe working practices. Most importantly, employers need to prepare risk assessments, and this is a theme that you'll find in all insurance injury cases. The importance of risk assessments was emphasised by the Supreme Court in the case of Kennedy and Cordia, 2016. This case involved an accident to a carer who was visiting a sick person at home. The conditions in that person's house, outside the house, were slippery, and the home carer slipped and fell. So she brought a claim, and at first instance she was successful. However, in appeal she lost, and the case went all the way to the Supreme Court. And during that case, the Supreme Court took the opportunity to reinstate the importance of employers doing risk assessments. So it's a very useful authority when you're talking to insureds and companies about the importance of doing risk assessments. It goes without saying that ideally it's not enough to just do a risk assessment. It's important that those findings are recorded. And clearly in relation to home working, it's also important that as workstations change and companies and individuals change their workstations, that those workstations or that the risk assessments themselves are updated. Okay, so what about the HSE guidance? Well, not surprisingly, in relation to home working, the HSE has updated their guidance in relation to home working. Essentially, that guidance is quite helpful in my view, but it essentially extends a flexible and proportionate. It suggests that employers take a flexible and a proportionate approach to the risks, and that as a result of the pandemic that we're facing. So really the overall approach from the HSE is to be flexible and proportionate. The guidance states that employers should consider what work activity staff will be doing, and secondly, whether control measures need to be put in place to address that work. However, critically, according to the HSE Guidance Note, there is no increased risk when doing any screen equipment work for those working from home temporarily. So employers do not currently need to undertake full home workstation assessments, so that's quite helpful for employers. The advice does suggest that employers could provide employees with advice in completing their own basic risk assessments at home, which might include, firstly, providing information on the importance of posture and how to make equipment adjustments, and also the importance of taking breaks. Secondly, that employers should make it clear to employees that they must raise any problems that they have at home if they start to suffer any physical symptoms. The guidance does urge employers to provide specialised display screen equipment regulations where appropriate, and that may mean at times employees taking equipment from their office workstations. I think now that we've been home working for 6 or 7 months, quite a lot of firms are actually giving staff their own budgets, and again that needs to be carefully managed by firms to make sure the appropriate equipment is bought. So as I said, essentially what the HSE have said is that, that we are to be regarded as temporary home workers. So what is the definition of a temporary home worker? Well, essentially temporary isn't defined at all, but according to the Cambridge Dictionary, it says that temporary is something defined as not lasting or not needed for very long. In my opinion at the moment, I think the HSE are taking the view that what we are doing is temporary, but again, it's questionable how long that can remain the position, as 3 months stretches to 6 months, and that in turn stretches to a year. So it wouldn't surprise me if the current guidance from the HSE is updated to take account of the much longer period of time that we're working at home. The HSE guidance is helpful and supportive to companies and insurers and will assist in relation to the defence of claims involving the display screen equipment regulations. However, in my view, it would be prudent for companies and employers to provide guidance and information about health and safety at work arising from home working, and to encourage and remind staff to do their own workstation risk assessments. It's also sensible for staff to provide business or to provide equipment where that's appropriate. Okay, so that's enough about physical risks. What about mental health risks? There's no question that the pandemic is having an impact on mental health. I quoted some stats at the start of it, and I think that we will all have those conversations with our own colleagues where some people are feeling down about the sheer physical isolation arising from home working. In terms of the legal obligations for an employer, essentially for mental health risks, they're the same as for physical risks. Of course, with mental health, it's much more difficult for employers to be able to identify and address problems that employees may have. So what exactly are the legal obligations in relation to mental health? Well, there was very helpful guidance identified by the Court of Appeal in the case of Hatton and Sutherland, which was a landmark stress at work case. Essentially, from an employer's point of view, the issue that needs to be addressed is whether the kind of harm suffered by an employee was foreseeable, and in particular, whether an employer knew or should have known about an employee's mental health problems and taken steps to address them. In this respect, an employer is usually entitled to assume that the employee can withstand the normal pressures of the job. There are no occupations to be regarded as intrinsically dangerous to mental health. To trigger a duty on the employer's part to take care, there needs to be indications of impending harm arising from the stress at work, which must be plain enough for any reasonable employer to act upon them. So how does that guidance apply when most of us are working at home? And it's really very difficult for employers to do anything about to identify these risks. Well, again, the HSE has provided some guidance in relation to this topic, but it is really quite brief. The guidance states that home working can cause stress and affect people's mental health. It acknowledges that being away from managers and colleagues can make it difficult to get proper support. And it recommends that employers put in place procedures so they can keep in direct contact with home workers and recognize the signs of stress from staff as early as possible. So all good common sense stuff. It also recommends that businesses have an emergency point of contact for staff. So again, that makes sense too. I think the guidance from the HSE is helpful to businesses, and it acknowledges the difficulties that employers will have in supporting entire workforces working at home. I think in reality it will be incumbent on employees themselves to clearly flag mental health issues with their managers, and in the absence of that, I think companies will be able to say that they weren't aware of the problems and therefore weren't able to address them. So I think that really it is incumbent on employees themselves to raise issues. So moving on, what steps can businesses take? Well, quite a lot of these, frankly, a lot of businesses have already taken. So I'm not going to run through all of these, but clearly most of us are now doing lots and lots of remote meetings, and we're all doing coffee mornings and quizzes and all that sort of stuff. So I think that's nice, really standard for businesses. There was a survey by Mercer, and some of the information thrown up by that I thought was quite interesting. So 43% of employees felt that their companies were addressing the issue of psychological stress, but only 15% of employers had actually surveyed their staff to understand their needs. So I got that stat a couple of months ago. I'd be very interested to know whether more businesses have actually carried out staff surveys in relation to mental health risks. I've mentioned about buddying, and again, that's something that quite a lot of firms have done. I think the other big issue in terms of home working is the whole issue of furloughing staff. That in itself does generate a huge amount of anxiety, and they're likely to experience morale problems, which will fuse with stress. From a business point of view, it's important that where staff are being furloughed, that the whole furloughing process needs to be carried out fairly and sensitively. So one other corollary, I think, of so many staff being furloughed is, of course, carrying out investigations from an insurance point of view has become very difficult indeed. Again, businesses need to take account of the fact that with furloughing, staff numbers are often reduced, and again, that can put more pressure on those staff remaining. Similarly, certainly first time round, there was a lot of people with childcare issues. That's not going to be a big problem during the current lockdown. But nevertheless, childcare issues remain an important stressor for a lot of different people. I think that the key point to take out of that is that there's so few businesses carrying out staff surveys. I think it is important that staff do keep an eye on people's mental health, and that employers should really be carrying out surveys to check that people's mental health, employees' mental health is holding up during these lockdowns. Okay, I'd now like to move on to look very briefly at causation. Causation is one of those issues that's going to be very interesting to see how it plays out in COVID claims. My experience is that there haven't really been a huge number of actual COVID injury cases so far. Many insurers are very interested to find out about these cases. And while I understand that some businesses are getting a large number of notifications, there aren't that many claims. In fact, I picked up a COVID fatality claim last week. So I got a letter of action from the firm of solicitors called Thompson. So it will be interesting to see how all that plays out. And it may be that we're going to see quite a few of these in the future, but so far it's been surprisingly quiet. One of the big issues around COVID really is going to be causation. So essentially for a claimant, they have to prove causation. And of course, with COVID being so widespread, I think it will be difficult for them to show exactly where the exposure took place, whether that was in the workplace or on public transport. As I said, essentially, in order for a claimant to succeed, they have to show that the exposure in work, the negligent exposure in work, materially contributed to their injury. A lot will depend on the conditions at work and how sympathetic a court is, but essentially the obligation is for the claimant to show that the business has been negligent and hasn't had taken appropriate measures to protect the staff from COVID. So things like making sure the workstations are all separate and that there's plenty of cleaning points within the business. So those steps aren't taken. That's going to help a claimant to prove negligence. As I said, I think COVID-19, the big battle is going to be around causation. And again, there is going to be an interesting issue about whether it's classified as a disease. I think there's a real chance that the virus will be classified as a disease. And of course, in terms of disease, the but-for causation test has been modified in the context of disease claims to allow a claimant to succeed in a claim where they are unable to comply with the but-for test. In disease cases, we saw the case of Fairchild, which some of you may be familiar with. This was a Supreme Court case which involved mesothelioma. And in that case, the claimant couldn't prove that the asbestos fibre had caused the mesothelioma. It simply wasn't possible because the condition was an indivisible one. What the Supreme Court did was that they watered down the causation test, and they said that it was enough if the claimant could show that the exposure had increased the risk of the claimant's condition. And I think this is a likely line of attack for claimants, because at the moment we don't know whether the COVID-19 is an indivisible condition, whether it's caused by multiple exposures or whether one is sufficient to cause the condition. So I think that's going to be a really interesting area to establish whether COVID is an indivisible condition. And if it is, then I think on causation, it's going to be easier for claimants to succeed in these cases. But that's very much a developing area, and one that I think insurers and businesses want to watch very carefully. Okay, that's all I want to say really with regards to working at home and COVID. I'm now going to hand over to Kim, who's done a great job on my slides, by the way. So thank you very much for listening, and we'll pick up some questions at the end. Over to you, Kim.
Thanks, Joe. Yeah, you'll have to bear with me while I do slides and talk now for myself. So if anything goes wrong, you'll know why. I hopefully won't keep you too long. Today, I just wanted to quickly raise with you the emerging risk around accommodation claims. This follows the long-awaited judgment in Swift and Carpenter, which has become a test case for accommodation claims in personal injury litigation. It was handed down on 9th of October this year. So basically, Roberts and Johnstone established, that was the previous case, established a formula which set out to stop claimants achieving a windfall for their estate on death. It is recognised that severely injured claimants often require a new, more expensive property, but because their existing property no longer meets their post-injury needs. However, if a claimant were to simply be awarded the additional sum required to purchase suitable accommodation, this would result in windfall for their estate on death, contravening the fundamental principle laid down by the House of Lords in Wales that a claimant's damages should put them back in the position that they would have been in but for the accident, or as close to that as possible, but do no more than that. To avoid that windfall, in Roberts and Johnstone, the court arrived at a method that involved leaving claimants to purchase property from other capital, but at a time when property values were relatively modest, by reference to general damages and other heads of loss, but compensating them for the loss of return on the capital that they would have invested in order to make the purchase. The calculation under that method was capital difference times discount rate times lifetime multiplier. The problem with Roberts and Johnstone formula were threefold, the first of which was discussed in JR and Sheffield Teaching Hospital NHS Trust 2017. Roberts and Johnstone has always been contentious because in practice it requires most claimants to borrow from other heads of loss and their damages in order to purchase a property. In recent years, that has been compounded by soaring house prices, forcing claimants to look beyond their general damages and to utilise damages awarded for financial losses. In JR, Judge William Davis concluded that the appropriate award in respect of the additional cost of purchasing suitable accommodation had to be nil, but granted permission to appeal. The decision was appealed, but it settled before it ever reached the Court of Appeal, and hence we were left waiting for the Swift and Carpenter result. The second issue arises from the fact that in 1999, the House of Lords in the Thomas and Wells appeals tied the rates used in Roberts and Johnson methodology to the discount rate. So under the pre-2017 discount rate of plus 2.5%, that model always produced an award, albeit one that was often substantially short of the full capital cost of the property. In 2017, the discount rate was changed to minus 0.75% before rising slightly in 2019 to minus 0.25%, which is where we're at today. So under the Roberts and Johnson approach, those discount rates generate a negative damages value. And thirdly, claimants with shorter life expectancies were always hard done by. So Swift and Carpenter. The facts are that the claimant, Charlotte Swift, who was 39 at the time of the accident, suffered a below-knee amputation to her left leg and significant injury to her right leg as a result of a road traffic accident in 2013. The cost of suitable accommodation was estimated to be in the region of £2.35 million, which was £900,000 more than her pre-injury property. I have heard her legal team speak about this case, and they have described her as an exceptional claimant who had the right mix of intelligence and capability without losing sympathy. They gave an example of how, when she was looking for a prosthetist, she tracked down Heather Mills McCartney, or Heather Mills as she's now known, to find out who she had used when she underwent her amputation. So clearly she had means and method to properly conduct herself throughout the litigation, and a factor that her legal team considered important in pursuing the appeal. The first instance decision is seen as the leading case in quantifying amputation claims, and unfortunately, like this appeal, it is not a happy tale for dependent insurers, but that's a talk for another day. Today, we will focus on the accommodation aspect of Ms. Swift's claim. As I said, it was accepted that a suitable property would cost £2.35 million, which was £900,000 more than her pre-existing property. So adapting the Roberts and Johnson approach, the award in respect of the additional cost was nil. The Judge Lambert felt depressingly bound by Roberts and Johnson to make a nil award, but accepted that the Roberts approach was problematic in a number of circumstances, and so the claimant was granted permission to appeal. Now, when it went to the Court of Appeal, there was a very strong Court of Appeal to deal with the issues raised in Swift and Carpenter. You had Lord Justice Underhill, who is the Vice President of the Court of Appeal. You had Lord Justice Irwin in what was more or less his last case before he retired, someone with enormous expertise in personal injury law, and Lady Justice Nicola Davies, DBE. It was a very strong court to draw, and actually the suggestion to obtain expert evidence, especially on reversionary interest, was one that came from the bench itself, particularly Lord Justice Irwin. Reversionary interest, for those who don't know, is the value of the interest that the compensator would have had in the property if it was to revert to the compensator on death. This approach involves awarding the full additional capital cost of the accommodation and then deducting the value of the reversionary interest. The approach sounds simple, but the difficulty with it is identifying an appropriate method of valuing the interest in the absence of any truly comparable market for such interest. The matter was initially listed to be heard in July 2019, but it was adjourned so the parties could obtain expert evidence from a whole range of experts, including, as I've listed there, economists, actuaries, mortgage experts, an expert in the valuation of reversionary interest, and Richard Cropper, who is a very well-known financial advisor who had no opposite number in this case, but was used to stress test some of the options available or proffered by the experts. The matter was adjourned again in March 2020 at the start of the pandemic, and actually, what some people don't know is the Court of Appeal offered to continue with the case by telephone, but none of the parties, including PIBA, the Personal Injury Bar Association, who had joined as an intervener, wanted to proceed by telephone, so it was adjourned. The Court of Appeal finally heard submissions and live evidence from experts over 3 days via video link from 23rd to the 25th of June this year using Skype for Business. So a number of other potential methodologies were dismissed by the parties as not being viable, especially because their experts concluded so. These included a lump sum or periodical payments order award based on the cost of an interest-only mortgage. This was due to the unavailability of any suitable products, which was actually an interesting result to come from this, as that was at one stage seen as a way forward, but there simply aren't any products available on the market. The second that was dismissed was the use of a life multiplier and a mortgage rate on an annual rental, for the simple reason that in most cases where there's a decent life expectancy, the resultant sum ends up actually more larger than the additional sum sought in the first place. And lastly, loans from dependents, as most institutional dependents are not set up to provide loans to claimants. Although some could put themselves in a position to do so, there's no real incentive to do that. So in Swift and Carpenter, the Court of Appeal judgment was handed down on 9th of October, and it comes as no surprise that the appeal was allowed. The judgment of the court unanimously allowed the appeal, finding in favour of the claimant. The court found that accommodation claims should be valued at the additional capital cost minus the value of the reversionary interest, based on a discount rate of plus 5%. It was debated heavily whether the Court of Appeal were bound by Roberts and Johnson. When deciding this, it was PIBA, the intervener, that suggested it should be treated as guidance. Lord Justice Irwin said that in the context of modern property prices and a negative discount rate, the formula in Roberts and Johnson no longer achieved fair and reasonable compensation for an injured claimant, and that the reasoning in Roberts was a means to an end rather than a principle or end in itself, and stated that Roberts applies to this case, but in the form of authoritative guidance only. I've just put up a quote for him there, where basically he says it should be recognised as guidance and not an enunciation of legal principle. So at Swift and Carpenter, the court did recognise there was a need to avoid a windfall to the claimant's estate, if that can be achieved without prejudice to the principle of fair and reasonable compensation, but to withhold all damages, as is the case with the present negative discount rate, for the purpose of avoiding an eventual windfall is no longer acceptable. Lord Justice Irwin considered that the appropriate approach would be to deduct the windfall element from the full value of the additional capital cost of the property. Now, the question was how to calculate that windfall, and he concluded that the value of the reversionary interest would be a value based at the hypothetical date of death, provided the best answer. As already mentioned, this is problematic. The court had to find a way of valuing the current value of a future interest in property, which was subject to a wide range of factors. Having heard evidence on various methods of calculating the value of the reversionary interest, the court favoured a market value approach, concluding that the best measure of the value is what people will pay to acquire it. However, the current market and reversionary interest is at present very small and somewhat different in nature, so setting the value of such an interest was not straightforward. The court considered that the best way of doing this was to apply a discount or investment rate. Having considered the various rates adopted or proposed by the parties, the court took a cautious approach and adopted the plus 5%. This was much larger than the defendant's proposed rate of 1.1% to the claimant's 7%. The court accepted that their guidance should not be regarded as a straitjacket to be applied universally and rigidly. There may be cases where it's inappropriate. As Lord Justice Irwin explained, for longer lives during conditions of negative or low positive discount rates and subject to particular circumstances, this guidance should be regarded as enduring. So if you want to challenge it, you simply turn that on its head. So for cases with shorter life expectancy and where there's a high positive discount rate, it's open to challenge. So applying the above to the claimant's case, the Court of Appeal quashed the decision of the judge in refusing to make any award in respect of an identified need for £900,000 to purchase a more expensive house. The appropriate award, applying a 5% discount rate to the claimant's life expectancy of 45.43 years, yielded a value for the reversionary interest of £98,087, which then subtracted from £900,000 produced damages of £801,913. The court's award is consistent with using a plus 5% column from Table 35 of the 8th edition of the Ogden Tables. I believe that the applicable plus 5% discount rate tables will soon be made available. However, in the meantime, I've put up the calculation on the slides, so you have it. You can ask for the slides after, I'll send them out, no problem, and have included what exactly you should put in to your scientific calculator to make it as easy as possible for you. The only thing really left to think about when you're doing the calculation is life expectancy. I think it's worth just having it in here for you, so you remember that life expectancy is the first input required from the Ogden tables. If it's not been fixed by clinical opinion, agreement, or judicial finding. So the overall approach is conventional. If life expectancy is a fixed period, it can be used without more. If life expectancy is normal, it can be taken from table 1 or table 2 at 0%, or if life expectancy is expressed in the medical evidence to be reduced by a number of years, then it's taken from table 1 or 2 and adjusted by that many years. So fundamentally, the judgment makes a return to claimants receiving damages awards aimed at fulfilling their accommodation needs. Those awards are still discounted in acknowledgement of the windfall issue, and thus the principle of 100% compensation still stands. However, the accommodation award under the new model will frequently be substantial and represent a significant proportion of the required capital purchase cost, as was the outcome of Ms. Swift reflects. Neither insurers nor claimant representatives will view this judgment as optimal. It is also true to say that it does not represent a worst case for either claimants or defendants. However, defendant insurers may feel aggrieved where the Court of Appeal landed in terms of valuing the reversionary interest. The market for the sale of such interest appears incredibly small, and whilst the 5% value landed upon by the courts falls meaningfully short of the 6.2 to 7% bracket advanced by previous experts, it is further still from the 1.1% that the defendant was advancing. Perhaps the most significant aspect of the judgment, however, is the caveats around this model not constituting a straitjacket and being acknowledged as not appropriate for all situations. If at some point in the future we should end up with something other than a low positive discount rate, it seems inevitable that the application of this new model will be challenged. Moreover, its application in relation to cases involving claimants with a short life expectancy may be challenged straight away. Had Ms. Swift been 73 instead of 43 at the date of assessment, her award would have only been $475,000 by comparison to the $801 that she was awarded. And the residual aspects of her overall award available to borrow against would likely have been considerably smaller. So in that sense, this judgment represents only part of an answer to the thorny question of how to best compensate accommodation needs. Inevitably, there are going to be cases where it is said that the reversionary interest model is not appropriate. That will leave parties to their own devices in those situations, and unless they're able to come up with their own solutions, further litigation around this topic seems inevitable. Therefore, SWIFT may not be the final chapter when it comes to accommodation claims, but it is one that you and insurers alike need to be aware of. A review of all cases with potential accommodation claims should be actioned without delay, and this new formula should be factored into reserves going forward. So now I'm going to switch off my video, switch off my mic, and try and do Rob's slide. So over to you, Rob.
That's great. Thanks a lot, Kim, and good afternoon, everyone. It's great to have a chance to speak to you all today. I'm going to talk about two psychiatric disorders. Firstly, a gaming disorder, which is a newly recognised condition, and also opioid dependency disorders. So you'll go away today with some insight as to why we consider them to be potential emerging risks in the personal injury claims arena. So going back to basics, mental disorders are classified according to either the ICD, which is commonly used by UK doctors, or the DSM, which is mainly used in the US, but it's also used by some UK clinicians. ICD-11 is the latest version of the International Classification of Diseases, and it was in this version that a gaming disorder was first officially recognised. It doesn't actually appear in the DSM yet, but the DSM was last updated in 2013, which could explain that. On screen now, or sorry, if you go back a slide, Kim. On screen now sets out the diagnostic criteria for ICD-11 for a gaming disorder. In brief summary, it requires a pattern of prolonged gaming, usually over a period of 12 months, to the point that a person puts gaming over other essential activities such as daily care or going to work, for example, so it causes negative consequences for them. It's an emerging diagnosis. It was first adopted by the World Health Organization in May 2019. The Central and Northwest London NHS Foundation Trust first opened, well, it was the first NH clinic to open a clinic to treat the gaming disorder, and that was only in October 2019. As this research develops, we can expect a greater number of diagnoses, particularly in this day and age where there's a far greater emphasis on mental health and mental well-being. Recent studies have shown that up to 10% of young people in Western countries suffer from this disorder, and online gaming has been shown to have increased significantly during the COVID-19 crisis and lockdown. So you might be thinking, well, this is interesting, but how does this affect personal injury claims? Well, research has shown that 13 to 25-year-olds are at the highest risk group of developing a gaming disorder, and it often develops in response to a life stress. A claimant involved in a road traffic accident, for example, and they suffer, say, orthopedic injuries which render them homebound for 6 months, may seek to play video games, perhaps excessively, in order to pass time because they've got little else to do and they can't leave their home. Games are becoming more addictive generally as the technology becomes more advanced and developed. The next generation of consoles, the PlayStation 5 and the Xbox latest model, is actually due out later this month. RPG games in particular, that's role-playing games, have been found to be extremely addictive, and I think that's because they replicate various areas of real life. They allow users to submerge themselves in virtual worlds, and there's a lot of online social interaction. Studies have shown that some of the other most addictive games include Fortnite, Call of Duty, Minecraft, and World of Warcraft, some of which you may have heard of before. Gaming disorders have also been shown to link increased anxiety, social phobia, and depression. And so there's potential that developing a gaming disorder may lead to other potentially more serious psychiatric conditions. In China and South Korea, there's actually been cases of individuals dying from gaming addiction after playing games for several days, virtually non-stop. They haven't eaten, they haven't slept properly, and then they've died of issues related to exhaustion and dehydration. That hasn't happened in the UK yet, as far as I'm aware, but we can envisage scenarios where a claimant suffers physical injuries which will keep them homebound for, say, 6 months. However, during that time, they may develop a gaming disorder as an indirect consequence to the physical injury. This would add to their award for PSLA and potentially also increase the claims for loss of earnings and treatment. So in terms of treating a gaming disorder, as I mentioned earlier, the disorder has only recently been officially recognised, and so clinical evidence for the best way to treat it is still being gathered. The NHS clinic I mentioned offers a 12-week programme of individual and group counselling on an outpatient basis. Private clinics, however, offer residential stays for treatment, and costs can be in the region of £10,000 for a 4-week programme. So you can already see how a gaming disorder, if it's attributed to being secondary to a physical injury, treatment costs can quickly mount up and it can add significantly to the value of the claim. Our psychiatric expert would hopefully be able to advise on the reasonableness and effectiveness of any treatment regime which may be proposed. Could we get the next slide, please, Kim? Thank you. Next, I'm going to talk about opioid dependency disorders, which, although very different to a gaming disorder, does carry some current or some common themes and risks in a claim setting. Currently in the US, they're in the middle of what is being known as an opioid crisis, with large numbers of the population said to be addicted. There's ongoing litigation there at the moment, actually, but it's a bit different because a lot of it is against drug manufacturers. In the UK, in the last 20 years, there's been a 580% increase in high-dose, long-acting opioids being prescribed. The majority of this increase is driven by those suffering from chronic pain and chronic post-surgical pain. 1/8 of the adult population in the UK has been prescribed opioids at some time in their life, and opioids are responsible for a large percentage of the number of overdose deaths in the UK. For those of you that don't know, opioids are a form of drug sourced from the poppy plant, being the same raw source as heroin. They include, for example, fentanyl, morphine, and oxycodone, and have commonly been used to treat pain. They block pain receptors from the brain and release dopamine, and approximately 25% of users reported dependence. Side effects and withdrawal symptoms are common, and they include muscle and bone pain, sleep problems, vomiting, cold flashes, goosebumps, uncontrollable leg movements, and also severe cravings. On the screen now is the ICD-11 criteria for an opioid dependency disorder. It's essentially where a person uses and has a strong drive to use opioids, has cravings, and where priority is given to using opioids over other activities in daily life without any regard to the harm or negative consequences that it may cause. So the risk is that a person who is injured in an accident and uses opioids to control their pain, but consequently develops an opioid dependency disorder. Opioid disorders can also lead to other psychiatric conditions, such as depression, so it can lead to a somewhat downward spiral. Those most at risk of developing an opioid dependency disorder are those living in areas of high deprivation and also those suffering from mood disorders. Claimants with a history of mental and substance misuse are probably more at risk of developing a dependence, which may give us causation arguments, but you'll be familiar with the eggshell skull rule and the concept of taking a claimant as you find them. So in terms of treatment of an opioid dependency disorder, this typically involves detoxification, talking therapy, and aftercare. Detox programs can be very costly, particularly if it's on an inpatient basis. The Priory Clinic, for example, offers a 28-day addiction treatment program, which no doubt would be extremely expensive if it ever featured on a claimant's schedule of loss, no doubt into the many thousands of pounds. I'll put up on the screen at the moment an example of just how an opioid dependency disorder could adversely affect the value of a claim from our viewpoint. The figures could actually be well similar for a gaming disorder. On the left, there's a fairly routine claim by a person suffering from a leg fracture with an estimated 12-month recovery. If, however, that person develops an opioid disorder as a result of their injuries and requires further rehab, suddenly there's an increased claim for PSLA, loss of earnings, treatment, etc. And it's fairly easy to see how a fairly simple claim could suddenly become more complicated, more than double in value, and also increase in costs due to the extra work required and the additional expert evidence needed. I put up on the screen at the moment the case of GXG against S, obviously anonymised. This was a sexual assault case where the claimant developed an addiction to alcohol and cannabis following sexual assault by a neighbour. They were awarded sums relating to loss of their driver's licence as well as money wasted on alcohol due to their addiction. The extract of the judgment in red essentially makes clear that where an addiction is caused by an accident or breach of duty, the money wasted due to that addiction can be recovered. The same rationale could be applied to claimants who have subsequently squandered their money on, say, computer games, consoles, opioid prescriptions as a result of their dependency. It is worth bearing in mind, however, that on policy grounds, the court wouldn't allow recoverability of any illegal substances, notwithstanding the person's addiction. Another thing to consider with gaming disorders is that whilst claimants may be able to show that they only developed the disorder following the accident, many of them still played games anyway, so hopefully we could show that but for the index accident, they still would have purchased the same games, the same consoles, even if they didn't play them as much, and so there isn't actually any loss there. The same argument, unfortunately, is going to be more difficult for those who are addicted to prescribed opioids if those opioids were only prescribed as a consequence of their physical injuries. So how else, as defendants, can we push back? The best way for a defendant to do so would usually be by obtaining our own psychiatric expert evidence, where we can try and challenge the claimant's diagnosis. Like with many psychiatric disorders, there's a large element of subjective self-reporting, which the expert needs to rely upon. It relies on claimants telling the truth as to the extent of their injuries and addiction. Another factor would be if we could show that either condition would have developed but for the index accident, or, for example, was caused by something completely unrelated. Can we show the claimant was a heavy gamer prior to the accident? We could seek e-disclosure of their online gaming account showing how often they played video games prior to the accident. This may show that they had a pattern of unhealthy, excessive gaming, or perhaps they were up late at night on weekdays when they had work the next day, for example. Surveillance could be another crucial tool. For example, does it show the claimant going about normal day-to-day activities when they've told their medical legal expert they really can't leave the house due to the level of their addiction? I mentioned earlier that courts will not award damages for losses sustained due to illegality, even if there is a recognised condition. The case of AB against Devon NHS Trust involved a claimant who had a history of Class A drug usage, but suffered a spinal cord injury at the age of 43 as a result of medical negligence and was rendered paraplegic. The claimant lacked capacity at various times pre and post-accident due to their drug usage and sought to recover significant professional deputyship costs as part of their claim, on the basis that but for the medical negligence, such costs wouldn't have been needed to handle the large sum he was about to recover. The court rejected this argument as well as the substantial claims for the deputyship fees on the basis that the lack of capacity and so the need for such fees was only due to the claimant's use of illegal drugs, and therefore these sums were denied on illegality grounds. So in summary, when reserving, it's worth keeping in mind that one psychiatric condition can lead to another, and even seemingly straightforward physical injuries can lead to psychiatric injuries which can add significant sums to the value of the claim. Red flags to look for would be any reports, whether it's via medical records, opponents, solicitors, or co-workers in the context of an EL claim, of excessive gaming by the claimant, particularly to the detriment of other daily activities. Also be alive to the issue of overprescription of opioids. Studies have shown that usage for over 12 months may be ineffective to treat chronic pain, and if this level of prescribing is apparent from the medical records, questions should really be asked. Where there are red flags and the claimant alleges that due to their opioid dependency disorder or their gaming disorder, they're, for example, unable to go to work and it seems like a claim is going that way, consider early intervention and offering rehab in the form of, say, therapy. Early intervention may work out far cheaper than if faced later down the line with a more significant claim for an in-house residential program. And finally, expert evidence from a psychiatrist will be key to challenging the diagnosis as well as causation and treatment costs. So when faced with a claim of this nature, it's very important that we have a robust, good psychologist on our side, or psychiatrist rather. So thank you all for listening. That concludes my part of the talk, and I'll pass over to whoever who wishes to ask any questions of Joe, Kim or I.
Yes, indeed, we do have. Thank you, Robert, and thank you, Joe and Kim. We have a couple of questions here. I think the first one is for you, Joe, around COVID causation. And what are your views about office and air conditioning systems potentially causing COVID?
Yeah, well, first of all, can I just hope we haven't ruined anyone's lunch. So it's been great to speak to everyone today. So far as air conditioning is concerned, I mean, I think essentially the rules will be the same, namely, you know, there's going to be an obligation really on employers to ensure the places of work are safe in accordance with COSH, to ensure that that the general health and safety obligations are complied with. So if there is any breach of those, then an employer is going to be held liable for that. So the very first thing an employer has to do is show that they've got the systems in place really to deal with the greater risks posed by COVID. Now, speaking about Kennedy's, for instance, I mean, I have been into the office occasionally, and it's clear that lots and lots of systems have been put in place to address the risk from COVID. And I suspect that many employers are just like that, really. They have taken greater measures. So I think on negligence, you know, the same obligations are going to be on employers. And as I said earlier, the real battle is causation, and that will depend on whether COVID is defined as a divisible or indivisible condition.
Joe, we have another question here from you. To what extent can remote monitoring of an employee may be a warning sign if it illustrates no breaks, unusual work patterns?
Yeah, well, if that is the case, if you're seeing those signs, then I mean, it'll be very difficult for employers to pick that up. But again, they have to make sure that they regularly assess employees' work systems. And obviously, you can now look at computers and computer use and see if people aren't having breaks regularly. And if that is the situation, then employers will be expected to step in, I think, and do something about it. It won't be enough to say, well, we had no idea that somebody was working like that. I don't think that will cut the mustard really going forward. So I think that initially the guidance from the HSE has been very gentle on employers, but I think with us all working at home more, that guidance is likely to firm up, and there will be an obligation on employers to really assess the sort of thing that you're talking about, Paula.
Okay, and we have another question here from one of our underwriters in the audience. Does the BI test case outcome actually change the causation and proof burden requirements for liability claims, particularly with Fairchild decision language?
Yeah, I mean, as we know from the recent decision, everything turned on the actual wording of the policies. And as we saw in Fairchild, there is a difference between interpreting when the material policy responds, depending on whether it's a PL or EL. So I think a lot will depend on the actual wording itself. And as we find with the recent cases that went to the Court of Appeal, really, or that were decided by the High Court, rather, in relation to property and the business interruption, it all turned on the actual wordings themselves. So some insurers managed okay in terms of the cases, others didn't. So again, the same thing I think will apply in terms of causation. You'll need to look at the actual wordings themselves.
And we have a question for Kim, please. So how is SWIFT applied to a claimant who is renting property and has no capital value in the property?
The same calculation will need to be required, because if she has to, the rental cost will still be deducted from the overall windfall, and there are. Sorry, I've just gone back.
No, don't worry, Kim. I mean, if it's you've been busy doing the slides, so whereas I've been sitting here doing nothing. Essentially, with rental, I mean, what I'm seeing in cases is that we will do a calculation for what somebody was likely to buy. So when you've got a young person who doesn't own any property, you will pick a property that they are likely to have bought in the future and deduct that from the property that they're actually going to buy because of their disability. And therefore you apply the same calculation that Kim was talking about. So it depends really. You can offset the rent, or you can offset the likely house that they would have bought in the future, and then do the usual calculations.
That was what I was trying to say. Deduct the rental cost, or deduct the cost of the house that they're likely to buy.
Thank you. I just have a final one to wrap it all up, and this one is for Robert. So can it be argued, Robert, that the chain of causation has been broken if a claimant develops an opioid disorder after an accident, but their doctor didn't follow clinical guidelines when prescribing them?
That's a good question. It is possible in theory. There are now very strict guidance to doctors on prescribing opioids, because this issue is becoming more alive and people are realising how addictive these substances really are. The problem from our viewpoint, though, and this is the same principle for most personal injury claims where there's subsequently some clinical negligence, is that we would need to show the treating doctor was negligent, not just negligent, but grossly negligent to the criminal standard, in order to break the chain of causation. And for that reason, although it's possible when it's an argument to consider, I think in real terms, it's probably going to pop up in a very small handful of cases.
Thank you, Robert. And it's been a very, very interesting presentation. Certainly for me, it's been an eye-opener. I mean, we know about the home working and we're all in that situation, but particularly with regard to what's coming down the track in relation to opioids and gaming, it's quite concerning. But thank you, all three of you, and it's been excellent, as I say, and thank you to our audience for joining us.
Yeah, thank you.
an eye out for our next website being hosted by Connexus, Clyde & Co and Boston Tallis. All of these are to come. So thank you once again. Thank you to Kennedy's and to our speakers. Goodbye and have a good afternoon. Thank you.